There. Okay. What we're going to do today and throughout this year is to assist, make sure when you come in late, you've got to scan in to get credit. And there's some scan sheets somewhere around here. Where are the scan sheets? Okay. Okay, one there and one there. There were three originally. Okay. All righty. But what we have to do is, well, we'll just wait until everybody wants to. Yeah, but I'll tell you about that later. The other thing is that in order for you to get credit to this class, you have to scan out. That's just a little I didn't know that. They just handed that to me today. So anyway, what we need to do is throughout our practice of real estate, we always need to incorporate the best business practices. And that's really what I present to you every month, besides telling you some of the things you shouldn't do or some things you need to do. At the end of every one of the sessions that I'll do this year, when it's applicable, we're going to have a little benchmark evaluation, just as we did last year. And that assists the broker in complying with the broker responsibility rules. The broker has the right now to determine your proficiency on every transaction. And so that means that's your responsibility. If you don't know something, you've got to ask, right? You've got to ask for help. And sometimes we go through class and, you glazed over look. Some people want to run screaming from the room. But really, it's just an affirmation. What was I presented today? And what do I need to focus on to make sure that I complete and do? So that's really what we're going to do this year. The first thing we started with are listings. How many of you are listing agents? Everybody in the room, raise your hand. There you go. There's a saying, you list to last. And when I first joined real estate, I kept thinking, what is this hokey saying that they have? Well, it is absolutely true. And you always want your sign where the same people are going to go by it 5 times a day, and they're going to think you're everywhere. And it works. That's how it works. But when you list a property, you actually have to know something. I love Gary Keller. Everybody know who Gary Keller is? Okay, well, he taught a class years and years ago to us. I've been with Keller Williams since '96. And he said, when we first get our license, we usually do work with buyers, right? It's not that you don't have to know something for buyers, because next month all you agents will know what you better do when you work with buyers. But you have to know the market. You have to know how to promote the property. Do you know what I'm saying? You have to know a whole lot more things that usually you don't know the minute you get your license. For some of us, it might take a little longer than just a few transactions to really become proficient in some things. What I'm going to point out to you today are some areas that we need to focus on. The first one is I'm going to reiterate the broker responsibility rules that might apply to you so that you can help assist in complying with them. The next one, I'm going to tell you what you better do before you ever list a property, period. And then I'm going to review some of the items on the seller's estimated net sheet. Has anybody ever done a net sheet? Again, everybody raise your hand. Yes, okay, there you go. With buyers, we have the lender many times that provides those types of documents, those good faith estimates, but with sellers, we are the source. So we have to do a really good job. We have to identify a lot of things on it so that it will never come as a surprise to the seller at the end. So we're going to talk about that. We're going to talk about the seller's disclosure because that's the one document and the reason that agents get brought and their brokerages get brought into lawsuits. A buyer says, well, the seller didn't tell me this and the listing agent knew it, all those kinds of things. And so it's a very important document, but you have to make sure you have no fingerprint on it. And there's a way to do that. Then we're going to talk about multiple offers because not only did I get calls until last night about it, if you don't do it perfectly as a listing agent, you will be in serious trouble. Not so much your seller, but you personally. And so you've got to make sure that you do it perfectly because the only person they're going to blame if you mishandle it is you, the listing agent. So we'll talk about that. Earnest money disputes. I don't know about you, but did you see that it said Keller Williams Law Firm out front? And yet every seller thinks that we are going to pay all their legal bills to get their earnest money back because they want us to. So we're going to talk about that. And you say, well, why would you talk about that at the listing? Well, you're going to prepare the way, because by the time you get to an earnest money dispute, not very many people are reasonable and rational. So it's better that you kind of set the framework for them. You have to set expectations all along the way. Otherwise, they're going to assume that this is what your job is and this is what you do. And the last one is, unfortunately, we still have hijacked listings and we still have wire fraud. It's getting a little bit more sophisticated, so you, even from a seller, everybody remember the KW wire fraud notice that we got? We got it in 2015 because I worked for an office that the sellers were involved. Not the buyers, but the sellers. And what it showed us is that the attorney fee office of the title company kept blaming us because it looked like the email came from the listing agent asking for the seller's proceeds to be wired, right? And so we had to involve Keller Williams International on it because the attorneys were blaming us, the attorneys at the title fee office. And what it turned out is International came in, they vetted it, it didn't come from the listing agent, it didn't come from Keller Williams. Wound up, the title company, that fee attorney office, was the one that was hacked. So that was kind of like our real entree into it, and it came from a listing agent side. We have tons of them that come from buyer's agent side, but we'll talk about how important it is for you to explain that to your sellers as well. Okay, just a real quick overview of your responsibility rules. If you're a lead agent on a team, you must complete the broker responsibility course every 2 years when your renewal. This is a 6-hour course. It goes through exactly what the broker is responsible for. Have any of you ever taken that class? Yes. We've had agents who've joined Keller Williams after taking that class when they were with another brokerage because they came up and said, my other brokerage never did this. You know, and they were aware of it once they took the course. But you must take that course because at that point in time, the broker can appoint you as a designate when you're a lead agent. The broker holds, the designated broker holds all the licenses of everybody, even those that are on your team. And they only can appoint you if you have completed the proper prerequisites for to be appointed as a designate on something like that. I'm just going to tell you, all you newbies, we love you. It's very difficult to this industry, and it's hard to be new. Does everybody remember being new? I still do, and it was 1993. It was a long time ago, but it was frightening. But again, what we have to know is that please only ask individuals that have more experience in real estate than you. So sometimes because we're in the same class together, we joined at the same time, everybody kind of networks together. But when it comes important to really understanding the use of the form, when to use the form, how to address this with your clients, you need to really only contact those that are devised as the designate of a broker, somebody who really knows what they're doing and can respond for you. If you have a transaction, you are required to provide all your communications during the transaction to the broker prior to closing. That means all text, all emails, everything. It's substantive conversation that you may have had maybe with the title company, the inspector, the survey company, the lender, the other agent, your clients. All of those are required to be in the possession of the broker prior to your closing. And how many are doing that now? That's what I thought. We have one hand. Okay, but that is what you have to do, because who owns all of this communication? Yeah, the broker does. See, and Trek clearly identified it. When in years past, they had this real broad term. And so when they used that broad term, everybody could interpret it differently. But the workforce that came out and placed all these new broker responsibility rules in 2017 was very clear that it has to be in the broker's possession because those are their documents. My thing is, if you do get text a lot, you will have to use an app that will download every text. You can't use screenshots. That is not admissible evidence. So you have to download those text messages in a file format that the attorneys, in the event we had to, could use them as evidence. And it'll look much like emails, the way that the applications are. It costs you money, and depending upon the type of phone you have, those cell providers have different apps for it. But again, that's what you're looking for. It'll look similar to what an email log would look like. The individual who sent it, date and time that they sent it, who it went to, and what the text was. It's very, very important that that be in that format when you download it. Okay, the next thing is, as I said before, your broker has to determine your proficiency. The TREC rules are really defined and clearly identified that now the broker has to determine on every transaction. And what that means is, in the event there's an agent that keeps using repealed forms or incorrect forms, the broker has to step in. They may say, you know what, you need to go to more training, or they said you can't do the next transaction without it being supervised. It just depends, but TREC said to them, this is what you do. And it doesn't mean that it's violating any of the rulings that the IRS definitions of employer-employee. This is part of the broker responsibility rules. They clearly said it doesn't mean employer-employee type of provisions. And the last, you need to come up to the microphones. Okay, you've got one.
Okay, on the last thing where you're saying where all the transactions, all the communications, all the texts and emails and etc. need to be downloaded and sent prior to closing.
They're going to be in a folder. I called it before communications.
Okay.
You never submit it, but you download it all into the communication folder.
Okay, because we don't need to send it to them. We just need to.
No. It's not sent. It's just where we can gain access to it.
All right.
Okay.
And so that way I got to make sure I don't use any curse words in my communication.
That's true. We don't want to ever use profane language. If the other party does, you don't participate in that. Don't get colorful like that. That's not very appropriate.
I believe in CYA. I was just joking.
I know you were. I know you. The other thing is, say for instance you worked with this buyer and you put 3 other offers in. You would need all, even though they didn't get those 3 other offers accepted, there's going to be communications for every last one of those. It's very powerful information, I'll tell you why. We've gotten out of a lot of lawsuits when the agent was really good on documenting a pattern of behavior of the clients that they represented. And so they were able to show on the prior transactions that did go forward, this is what they knew, this is what they were informed of. It's just invaluable, So it's a really good thing for you to make sure that you do. It really helps protect you as well as your brokerage. And the last thing that's kind of important is that the brokers were told that no agent can do their first transaction alone. They have to have supervision. And that's a great thing, because in my day, you were on your own. There was nobody who was going to hold your hand or say or look or overlook at your information or see what you filled in the blanks or what was the questions that your buyers or sellers may have asked you. The other thing is that if you've never done a listing, that would be a first, wouldn't it? If you've never worked with a landlord, that would be a first. If you've never worked with a tenant, that would be a first. So again, just don't think it's the first buyer that you work with and then it's really any type of transaction where you haven't done one like that before or haven't done one before. That's really important for you to make sure on something like that. Yes?
I'm not going to take up the whole, I promise.
Oh, I bet you are.
I won't. But I want to say, I think all the new agents have to go through their coaches, through Chuck or Kelly, up to $700,000. That they have to take their paperwork through him. And so the newbies, they can tell me if I'm wrong, but I think that went in place.
Right, but a lot of times, if the agent doesn't tell anybody anything, that's why I'm saying it, that they personally have to reach out. They can't do this on their own. You can never attempt to do it on your own. You have to reach out to that person or that party that's going to be supervising you on the transaction. That's your obligation. Because I don't know about you, but we're not psychic. We don't know what's going on. You're the only one that knows this. This is why I'm trying to tell you about what you need to make sure that you assist with the complying with the broker's responsibility rules. Okay. It's right behind you, yeah.
Who assigns you with that supervisor?
Supervisor, the broker will, or one of their designates, or if you're in a coaching program, it's the coaches. Okay. What do you need to do prior to listing the property? Oh, yeah. You know, we get that opportunity call, and we're so excited that we forget to do a little bit of fact-finding and due diligence before we get everybody to sign it. And this year in 2020, we're not going to do that anymore. We're going to absolutely do our due diligence. My biggest concern is on the legal updates in the years past, they have blamed the listing agent for having a listing where it was a short sale and they didn't cover that. In other words, that there was property taxes that were owed and the seller now can't have enough proceeds and they'll have to bring money to closing. The only party that they blamed was the listing agent. So that's why you're always going to cross every T and dot every I when it comes to something like this. In other words, if you've got an opportunity call, and you're going to be very cordial, listen to them, take great copious notes while you're on that conversation. The minute you get off, now you're going to have to verify. The parties that just called you, you have to find out who is the owner of record. Because, see, we can only have listings with the real, true owners, or those that might be legally appointed to represent the owners. So in other words, you go to the appraisal district and you go in there and you say that John and Susie Smith called, but Sam and Jane Jones are the owners of record. Well, now you already have a little conflict, right? Well, I'm going to recommend that you look at the deed history. Deed history, actually, every deed has to be filed and recorded, and that can show you a recent deed history that was filed and recorded, but the parties that update that appraisal district information from the owner of record, they're not the same database. They're two different sources. That's why it's not always the same. And we could have had somebody buy a property and have a deed history in December, right? And now they contact you in January and they want you to list the property, but there's not the owner of record updated on the appraisal district. So make sure that you always verify that through the deed history. That's really going to be a true record of the courts that says this is the rightful owners to the property. Now, if you get this call and the property is held in another party's name, and they're different than the party that contacted you, there's going to be a little bit more conversation, isn't there? Yes, because now you've uncovered something. And sometimes we get involved in heirs or apparent heirs. They think they're heirs. We've gotten one where a nephew who had taken care of his uncle until his death wanted to list the property. Unfortunately, he wasn't an heir, but our agent just jumped on getting a listing agreement, and then it got under contract, and then the heirs were uncovered. There's no way out for a listing agent on something like that. That is disastrous. And my thing is, if anybody understands how important independent contractor status is, I believe in agents actually keeping their profit, what they earn. You're not a non-profit. You may volunteer for nonprofits, but in this classification of real estate activity, you're not a nonprofit. And my concern is when we get into a lot of these issues where you didn't do your due diligence as a listing agent, usually you're going to have to be the source of the response legally to get the other party off of your back, okay? And I don't like that. You haven't even earned anything, and then somebody is expecting you to pay all the damages because you didn't do your job. So, say for instance, this party calls you and you look and you say, well, the owner of record in the deed history show that so-and-so owns the property. Can you elaborate a little bit more on that? And then they'll elaborate and tell you various things. I am going to tell you that the minute they tell you that the deceased party that owns the property and is showing the owner of record, if they died intestate, which was without a will, there's a lot of different processes that have to go on before you'll even be able to put it in MLS, because you don't want to put it in MLS if your seller cannot convey clear title to that party. That's the problem for you. That's what MLS is about. It's about you procuring a ready, willing, and able buyer. But if your seller can't convey, you can't even go there, okay, until that's taken care of. In the case of a deceased individual, there could be that the court has appointed somebody to be the executor or the executrix. There could have been a will that was very clear who has the authority, testamentary documents that say, I can exercise in behalf of the estate. You know, there's going to be a legal document that gives verification to you as the listing agent. I have the authority to list this property for the estate. The estate is still the owner, but that individual could be an executor, an executrix, or it could be an appointee by the courts on something like that. If they're saying that their father or mother died without a will and you have all these siblings, well, that's when you're going to probably solicit the assistance of an excellent escrow agent at a title company. Each title company's underwriter has a threshold for what they require when you have these situations where affidavit of heirships might need to be acquired by all parties who might lay claim to the title, right? That's what has to be done. And those affidavit of heirships come in two ways. One of them, they might have secured them all, and then you'll list the property, and then at time of closing, they'll file and record all those affidavit of heirships proving that the new owner of the property was conveyed via the affidavit of heirships, okay, any claim to the title. The other one is that many times when you have heirs that want to get it in their name, they want to get that all settled before they list the property, which is a great thing. They will get their own affidavit of heirships filed and recorded, and it'll clearly say, now this party belongs to, the property now belongs to these parties. It could be all of them. I am going to tell you, just from an FYI standpoint, it's very difficult. We've had several transactions where we had multiple heirs. And when you have a lot of people that have to agree on everything on the listing, the list price, everything, get everything initialed, signed, and dated, it becomes a living nightmare for you. I think the worst one was we had 67. And the agent is like every other agent, I can do this. And then 2 years later, with all the various lawsuits of the various heirs suing each other, it was a nightmare. I've had agents come up to me and said, I personally have been sued by my brother for my mother's estate. Do you know what I'm saying? It happens a lot. My problem for you is that if you know that it's going to be a lot of people that you're going to have to work with, you can't come back later to us and say, oh my gosh, this is more work than I thought. You have to know that going in, it is a lot of work. Many times some of these heirs will have given power of attorney to another heir, and there's one heir that's representing maybe 3 or 4, but that's when the world is very wonderful and everybody works together. When it comes to money, there is no such thing. You know, this is just the reality of what we live in. And that brings me right into divorces. Why do you think they got divorced to begin with? They don't agree on anything, right? How many of you have ever handled divorce listings? Yes. I had judges that appointed me to be the listing agent, and you don't feel like you've gotten a crown on your head. You feel like somebody has just lowered the boom on your head, because whatever you say to one, you have to say perfectly to the other, because you can't show favoritism. And yet those two parties are trying to make you be on their side for everything, even the most ridiculous things. So it's very difficult. Sometimes we have people who don't know they're divorced. They weren't in the courtroom maybe when the judge put that gavel down. And I know this because one of my partners on one of my team, I sat in that courtroom with her while she went through her divorce, and it's a very hard bench, and you know how you just kind of, the whole element, and she didn't know she was divorced. I'm thinking, well, I just heard the judge, you know what I'm saying? It's hard. But you want to make sure that you have a legal document. You have to have it. People who are separated, oh, that's a real scary thing, because either they're both going to have to agree to everything on the listing, amendments, the offers, everything, Or the court could have, their attorneys could go to a court and say who will have the primary responsibility. But there will be a legal document. If they say, no, we're just separated, it's amicable, don't believe that. There is nothing about that that's amicable because of that. The biggest thing for you as a listing agent, if you're reading a divorce decree, it usually says who has responsibility for selling the property, that they could maybe choose the realtor, and the whole process will be theirs. It also shows an area that's very important to title companies. It talks about the division of any proceeds, if there are, from the sale of that property. But you don't go and put it in MLS till you have all of that in your possession. As I said, we had a lot of agents who kind of jumped the gun, and then the parties were divorced, and the judge issued a different decree than what that ex-spouse was telling us that's on a listing agreement that is not valid, because they both had to sign everything in order to be able to sell the property. And they think our job is easy, and we haven't even touched the surface, really. This whole process, you get that call or that opportunity call, it doesn't happen in 12 minutes that you've got all this. This takes time. And I really think that if we did a better job communicating to those individuals that we represent the process that you must follow each and every time, because you want to make sure that they are ready to go the moment you put it in MLS. We have a really great track record when we list properties. We usually sell them. Some of the other brokerages aren't like that, but Keller Williams tends to be that way. So that's why you have to make sure you really have this process down and that you, to your best of your ability. And do we normally just rely upon what a seller says? We can't do that anymore. We could when I first started in real estate, but now things have changed. We can listen to them, we can be very cordial, but we have to verify everything. And that's the way it's shifted. It's really because why? You are the professional, and NAR advertises you as being an expert. TAR advertises you as an expert. HAR, do you know what I'm saying? Everybody out there telling everybody you're an expert. And this process is very cumbersome. It's difficult sometimes and complex. And so you have to make sure you do a really good job. If you have been approached by somebody and you were talking with them, and the next thing you know, you go into the appraisal district information and you see the property is in the name of a trust. Well, hold on to your chair, because you have to have the trust instrument. It's a legal document, and you actually have to read it. In the trust document, there's a lot of complex information, but bottom line is it's going to tell you who can sell the property, lease it, or purchase, and how many trustees are going to be involved. Okay, you have to be really careful. As I said, you have to acquire all these legal documents, and while we're not attorneys, we actually can read. And those documents, for those types of things, are usually pretty clear, because the parties that signed them and the judge approved it, they have to understand how to uphold it. So there can be some legal language mixed in all of those provisions. But bottom line, everybody kind of knows who's in charge, who can do these things. We've had partnerships, LLCs. You have to get all those articles, you have to look at them, and you have to find out, is the person who's talking to me, do they have legal authority to list this property or lease the property? So that's your job, and it doesn't happen quickly. If you're relying upon the party that called you to give you those documents, that's when it can stretch to maybe weeks. You know what I'm saying? I'll get that to you. Let's just go ahead and put it in MLS. No, that's not how this process works. We're going to do things the right way because it benefits you only. So make sure that you do that and look at those documents and see who really has authority. The next thing I'm going to tell you is something that just drives me crazy. Oh, Marilyn, only one thing? Well, no, this thing really does. LLCs, trust, corporations have no hands. They don't have hands. They can't sign. And what infuriates me, every one of us in this room and in this universe can only sign their name legally. You can only sign your own name, period. So if John Doe is the trustee, it's going to be John Doe, comma, trustee for the XYZ trust. And if you don't know how to do that, because see, it's digitized and electronic and all that, well, you're going to find out how.
Oh, yeah.
Because there's no excuse for you not doing the right thing. And also, as listing agents, when you get offers and it's not done well, your sellers need to know who is acting in behalf of this LLC, this trust, this company. That's your job as a listing agent. So make sure that nothing gets offered to you that's not correct. You have to go to a microphone to be able to ask a question. Yes.
In a divorce case, because I have one right now, how do I need to ask for the documents?
The
Do I need
divorce
to go-
decree. Yeah, and they don't have to give you the whole decree, but you need the decree, and there'll be date and time stamped at the bottom because it's a recorded document. But what you'll need is where that applies for who has authority to do all of this, as well as how the proceeds will be divided. So you'll need to do it. You don't need all of how they're going to talk about every one of, those type of things. Yes, ma'am.
Sorry. For the LLC, is it exactly the same way, their name, comma, and then the name of the LLC?
Correct. It'll always be the person who has the legal authority to sign in behalf. For an estate, it's going to be Jane Doe, comma, executrix for the estate of Susie Smith. Okay, those that you only can sign your name ever on any legal document. Yes.
What if they're divorced or going through a divorce, but the husband's name is not on the property or the tax records?
Yeah, well, see, here's the problem I have for you. That separation thing is a really scary place. You will have to have some means by which they have an attorney who has advised them who can list the property and who can sell it. The problem is we're not going to legally say, oh, that ex-spouse, soon-to-be ex-spouse, contributed X number of dollars. It's part of their, you know what I'm saying? We're not going to do that. They're going to be the ones that are going to get their attorney to advise them that they have the ability to do this. We don't do that.
His name is not on the property?
But that doesn't mean that he might not need to be on the listing documents and contract documents. We don't make that determination. That's a legal determination on something like that. Well, separate property is something entirely different. That is when a person has acquired property prior to a marriage. We still don't determine if their new spouse shouldn't be on it. We don't know what they have done in the course of maintaining that property or contributing to it. So we do know that they have to sign at closing and funding to release any claim to it. But those kinds of things, you've got to get those really established, and as I said, prior to ever putting it in MLS, because you definitely don't want to offer it and then get into a situation where you have an offer on that property. The last thing that I'm going to talk about that is so important for you is to actually verify in MLS what is the history of this property that I'm able to go into MLS and look at it. That is very important. If you are a new agent and you see that there were 6 prior listings of less than 30 days by other brokerages, you might rethink taking on this listing. We've had so many agents who said, but I thought I could help them. We don't have, the psychiatric services or psychology services out front either, although we act like we do those all the time because many times we are required to almost act in that emotional capacity. But bottom line is, this is really important for you to know the history, what has transpired. And more importantly, if you went to the property in MLS and you saw that it was withdrawn, what does that tell you? It's still listed.
Yes.
That's what withdrawn means. Now, I'm going to give you a little hint. I don't believe anything that an agent puts in an MLS. So if a seller contacted me and wanted me to list their property and I saw in there that it was withdrawn, I'm going to make the seller go and prove everything. Not me. I'm not going to interfere with their prior listing agreement or their current listing agreement. It's the seller's responsibility to do all of that and come back and prove to you in writing. We've got great forms. We have forms that terminate a listing. We have a listing agreement that might show an expired date, all these kinds of things. So make sure that you don't do this, but you instruct the seller, look, I went into MLS and it says withdrawn. That means you have an active listing. No, I do not. Well, now you're going to have to prove that to me in writing signed by all of you and the other brokerage, but I cannot be involved in that. You have to be real clear about that because you could be construed as being the reason that they terminated that other listing early. Do you know those different types of things? And can you just willingly, just if you're a listing agent, say, you know, I'm going to just extend the expiration date a few more months. Can you do that on your own? Well, you better not. This is what we call a bilateral agreement. Nothing happens unless the sellers and the brokerage agree in writing. That's how it works. And the other thing is MLS has they have an at will. They can come to you at the brokerage and say, give me your listing agreement and all amendments. And if you can't prove that you had an amendment signed where the seller agreed to extend the expiration date, you're going to be in serious trouble. That's not how it works. It has to be mutually done because these are bilateral agreements. One party just doesn't get to make the decision on their own. Did you have a question?
If I have an expired listing, do I need to do something?
If it shows that it's expired, you might want to just quiz the seller a little bit about, I noticed that you have an expired listing. Now tell me what that prior broker or an agent didn't do that you would like to have me do it. You know what I'm saying? You become conversational. How many of you know what conversational means? Yeah, that means both of the parties are going to be given a little bit of it. It's not, you just can't assume all of these things. You know, there's a way to present it so that somebody will give you an answer better than maybe yes or no, that kind of thing. You want them to tell you the story because it assists you in really representing them better in the course of trying to procure a ready, willing, and able buyer and what their threshold might be or what they didn't like, what the other broker did or the other agent didn't do, those types of things. Now, I am going to tell you, all of these notations that we've seen in MLS, in 2019, we had more sellers, because see, the agents attended the class and they got worried because they went in there and saw terminated. Well, when you see terminated, you are going to say, whoa, now seller, you have to provide me the termination of listing that you and the previous broker agreed upon. That form is provided only by our association. They're copyrighted, so don't give them to a seller that you want to get their listing the next time because everybody will see your name down on the bottom of the form. Those are copyrighted, so no seller has them. They have to only come from those that are realtors, right? That's what a copyright means. That's what Texas Association of Realtors did. So what happens on this terminated, you're not going to do anything until the seller has presented to you in writing where the parties mutually agree to the termination terms. Our listing agreement doesn't have a clause about how you get to terminate. It gives more authority and benefit to the brokerage and says, we can terminate, but it's based upon our agreement of the terms. We had several instances where we made the sellers go back to the other broker. The sellers kept telling the agent, you know, I don't think I signed anything. And the agent kept thinking, oh, I'm sure you signed something, you just don't remember it, right? Well, no, there was never a signed listing agreement. And we had to have the broker in an email admit that they put the listing in MLS but never had a signed listing agreement. Because otherwise we couldn't go forward. Because it said terminated. So that's when I say I don't trust what I see in MLS. You see how it works? I'm not going to say that all of us are perfect at Keller Williams because we don't. We don't do the right things in MLS either. So that's why you have to make sure that the sellers always provide you the documents that show that. Because your duty to the seller, if you're going to be listing broker number 2, 3, or 4, you have to prove to that seller that they don't owe more than one broker commission, only the listing broker that they'll owe commission. Yes?
So an email wouldn't suffice? We'd have to have that form?
That's how it would work if they had a signed listing agreement. The broker could, if it's verified that it comes from the broker, they could say that they lay no claim to it. They have to specify all of those things that are on that form.
Okay.
That's
And
the
we're-
key to it.
And we're not supposed to provide them with the form,
You can't.
right?
It's a copyrighted form, and it'll show that you interfered.
Okay, good.
Yeah, and that's why you have to be really careful on something like that. Because you never want to be, we had some agents who picked up the phone and called the other broker. Well, now we've removed all doubt that we interfered. So don't do that. Do you know what I'm saying? There's just a proper protocol on something like that. That was a seller's previous listing agreement. We don't interfere with it, and we don't assist it in not complying with it. So again, that MLS information is very critical. You're looking for withdrawn. That's going to cause you problems. You're looking for terminated, which is going to cause you problems. If it's expired, you're really hoping that really it is expired. But if it is expired, you'd have to ask the seller some pointed questions saying, the previous broker did not name any exclusions in the future, did they? And that's where you have to have that conversation. Named exclusion is an addendum that can be on a listing agreement, but it's very clear that you're not going to go to a lot of money and time and expense on something like that. So named exclusions or exclusions that the other broker wants to have on this property with this seller, you'll need to ask about those as well. Yes?
When I look at the property detail and I see that it was terminated by, it shows termination and it's 6 months old, I still need to get the termination agreement?
I think I would, and the reason for that is we've had several of these instances, including even things that happened in this brokerage. The agent extended it for times past the actual signed expiration date, see? So you don't know you don't know if you can trust that data. You just want the seller to verify and get something in writing that will say, no, there are no exclusions and that type of thing. You have to be very careful. And that's really because you're not going to expend any time, talent, and effort and not receive any compensation. And this, again, our association provided a form for termination of listing that really benefits the brokerage, the first brokerage, of claiming compensation in the event it gets sold before the expiration that was existing on the listing agreement. So that's why you have to look at it very, very carefully from that standpoint. Okay. So now we're going to comment on some things on the listing agreement that you need to make sure are never blank. Blanks are not good even on the listing agreement, okay? Just make sure about that. Number one, this is about the listing content. In the listing agreement, they've given us two paragraphs, A and B in 6. A1B and 6B both say, 6B says I'm never putting it in MLS, and 6A1B says I'm going to put it in MLS after this happens, okay? And it gives you a little bit of space to write in and a number of days that are going to be a delay. We do that all the time when sellers need to maybe make the property ready for staging and professional photographs and those kinds of things. Well, you better have the HAR 300 form with you. HAR created this about 5 years ago because we had agents who were advertising pocket listings but not putting them in MLS. And even if you have a non-MLS listing, you have to notify HAR. They have a right to know that you have a listing that will not go in MLS or be delayed being placed in MLS. And part of this all ties in with what NAR has come down the pike and has given MLSs across the country until May to figure out about this coming soon and other provisions about non-MLS participation. It's going to be highly restrictive. HAR was really ahead of the game. They kind of had a form already that said either you don't put it in MLS or you're going to delay it for these reasons. The seller completes it, the broker signs it, and then you send it to HAR so they have it. That has to be done within 3 days of the listing commencing. So the first day of the listing commencement, the beginning date is day 1. So within 3 days, that's why nobody will sign that document if it's past 3 days, because how many days are you supposed to have that listing in MLS? 3 days. It may be 5 in the Texas Realtors form, but that's a statewide form, and it clearly states on that form, abide by your local MLS rules. And our local MLS rules are 3 days. Okay, so you have to be very careful. So that form's always going to be with your listing documents, because when you're talking to the sellers, all of a sudden something will come up and they go, you know, I don't mind our listing commencing, but I don't want to put it in MLS. I won't be ready for this many days for this reason. And so then you'll have to get the HAR completed by them and get it signed and off to HAR within those 3 days. And that's critical for you. NAR has come down the pike, and part of the reason is this coming soon. Agents have misused coming soon forever. You have to have a signed listing agreement to have coming soon, and per NAR, they want it, if you advertise anywhere publicly, you have to have coming soon in MLS within 1 day. So there's going to be a lot of issues on this, and it's because the agents have misused coming soon. A lot of listing brokers did it to benefit themselves, not necessarily the seller. And so it's also a discriminatory practice, and that was proven here by the emails that I get from agents that are only sending out their notification to certain agents. I have this pocket listing. And so that's really NAR's drive on this, is to stop the discriminatory practices that happen. It's going to be highly restrictive coming soon. As I said, if you put it out publicly that you have this property, within 1 day they're going to make you put it in MLS. So we'll see what HAR is going to comment on this, but a lot of them are following the guidelines that NAR has put out there, but with clear instructions so that we all clearly understand what is it that we can do if we advertise coming soon and what we will be limited by. So again, a lot of things coming on that. We don't have all the information yet. Paragraph 12E, F, and I, this is where the seller tells you, I'm not in arrears on my taxes. I'm not in arrears on my HOA dues or special assessments or my mortgage, all of those different things. You can never have that blank. And as a listing agent, what's going to happen on this is that you can't pre-fill out the listing agreement and ever send it to your client. The only way you could do that is per the seller's instructions. I want this in this field. I want this in this field. Normally, that's how agents do it when they have the face-to-face across the table from them, and you're going through the listing agreement with the sellers. But in this instance, we've had a lot of agents who leave it blank, and a blank would mean that you never reviewed that with the seller. So if the seller is in arrears or owes monies or different things, it's going to be on you. You're the problem, not the seller. Now, if the seller says none and we find out they didn't disclose properly to us, well, we have paragraph 13 of the listing agreement that will hold them responsible. But bottom line is, you're not going to have any blanks on this. It either is what the information is or none or NA, not applicable. Do you know what I'm saying? Don't leave it blank. The really good agents, what they do is when they have the listing agreement and they're working with the sellers, and you ask them that question because here it is a blank, we have to fill it in, and then the sellers tell you something, you fill it in, you better have them initial that. That'll make it a little more powerful for you because it'll prove that it was their instructions to you, because now they have affirmed it with their initials. These are our forms. These are not promulgated forms. So any kind of little initials you want, any highlighting that you want to do, you can do that type of thing on something like that. Just remember that they should never be blank, because it'll show that you never reviewed it with them, and that is your duty under TREC. Nobody gets to sign a document without having it explained to them. Yes?
In the previous one, number 6, 1, how can I change? How do I need to? I have here an agreement signed with number 1. It should be number B, the letter B.
6A1B?
So, can they say initial and change it with them?
Or you can do an amendment to the listing. But I have to have the date on whatever they change.
Or I can do that.
Yeah, well, and they gave us a form. It's called the Amendment to the Listing Agreement. I'd recommend using that. It shows a pattern of sequence that's a little bit more timely and easy to be identified.
And do I need still the hard 300 form?
Oh, absolutely, if you choose that or 6B. Okie doke. Now, does the listing agent need to sign the listing agreement? Yes or no?
Yes.
When? Sign it after the sellers have signed it. Do not sign it because you put it in compliance at the same time when you have a contract and getting ready to close. Because let me tell you what happened to a sweet little agent. They did that. They didn't comply with the rules. You put those listings into compliance once you put them in MLS. That's how it works. That you get that approved so that you don't have any hiccups. And God forbid if we are another set of eyes for you making sure all of the forms are complete. That's really what it means, okay? The problem is this listing agent put the listing in for review and the contract at the same time. So the listing has to be reviewed and meet compliance first because, see, it could mean your contract will never reach compliance. So we have to know that process. We have to know exactly. And what it showed is that the listing agent had failed to initial sign and date the listing agreement. So they did. And then they gave their seller a copy of it. And the seller actually reads. And the seller says, when we executed that contract, you and I did not have a listing. So good luck, and you're going to have to pay the other broker their compensation. And that's exactly right. Yeah, so don't do that. Do you understand how important that is? Same way with your buyer-tenant agreement. We'll talk about that next month with buyers. But this was serious because that's exactly right. These are bilateral agreements. Unless both parties sign it, you don't have anything. You see the difference? And I don't want you to get caught in a seller where you had really done a great job and procured a ready, willing, and able buyer and have an executed contract, and then they find a little loophole and now they're going to hang you with it. Okay? It happens, new agents, it happens to very experienced agents. I had it to one of the top teams in Houston just a couple of weeks ago. So this is not something that you better make sure you do. Now, I am going to tell you that if you get that listing agreement back from the seller and they've marked up stuff, do not sign it until you make sure that what you're agreeing to won't hurt you, okay? There's a couple of provisions for indemnification and hold harmless and showings and stuff like that, and those type of things are very critical. And a lot of times when sellers have attorneys, they just strike that all out and they want you to personally be responsible for everybody else that's going to come on the property. So we don't want you to sign something in the event that it could cause you personal liability. Yes? Yes, well, the minute anybody signs a document and the other party has signed it, and now we have a fully executed agreement, same way with contract, the other party has to actually get a copy because otherwise they're not going to believe that they have that, right? This is a bilateral agreement. The contract's bilateral agreement. Just because the buyer sent in an offer doesn't mean the seller has a contract, does it? So it's the same kind of thing. It's just that there must be a website somewhere out there to trap agents who have done this because it was very cruel what that seller did. Very horrific. And I don't know about you, but as I said, you're not a non-profit. And you don't want to have worked hard, done a great job, get it to closing, and now you have to pay for the other broker's commission? No, that's not how this works, okay? And as I said, you just don't know how people, they reveal themselves to us sometimes very late in the transaction. Yes? That's the beginning date on the listing agreement. See, there's a beginning date and an ending date. You don't have one yet. If you have two parties that must sign that listing agreement on the other side, they both have to sign in order for you to have an agreement. Yeah, but you don't have both sellers signing. Yeah, well, you don't have anything until you have a fully executed thing. Then you sign it, and then you have 3 days from the beginning date to do that. So again, if you're going to have that situation that he brought up where both parties are not going to sign at the same time, you're going to probably want to amend what? That beginning date? Kind of pay attention to that. Because you hate to have something hanging out there that's not right. The timing of it, it just gets a little crazy when you have that kind of situation on something like that. But it is very, very important. Never leave any blanks on it. Make sure that you initial sign and date it and then return it to them for completion. This poor sweet agent didn't realize that 2 days before closing, what she wanted to give the seller a copy of the signed agreement, and that's a good thing. It's just it caused a major problem on something like this. Okay, could an attorney prove that we had always complied with the terms of the listing agreement even though we hadn't signed it? Yeah, it'll personally cost you about $25,000 to get an attorney to take it on and prove it in a court. You know what I'm saying? And that's going to take a lot of time and money that you don't have to spend on something like this. So just make sure you do the right things. Take the time to look at it. I've had a lot of people sign things and they didn't read it. Can you believe that? Yeah, I know. It happens all the time. Agents do it all the time. That's what drives me crazy. Because any buyer or seller that we work with, we tell them to consult an attorney before they sign it. But as I said, just make sure that that is all well done, that they haven't modified it or crossed something out that could cause you kind of like a gotcha. So make sure you just take time to just look at it very calmly and then initial sign and date it if everything looks great. Yes?
Been a while. I'm back. On that not reading, I just dealt with an agent. She was a listing agent, and on the contract and special provisions, I request window coverings. And as we were doing the walkthrough, I said there was no window covering, and she responded in an email, well, we're not going to do that. We didn't see that. I said, well, it was in capital letters.
Well, it's already in paragraph 2, so we don't put something that's redundant anyway.
No, it wasn't, because it was a reverse mortgage foreclosure that they bought, and there was no blinds or window covering, so we had to request them. So it wasn't there for us to have when we went through the walkthrough, but we were requesting it for the end of the deal.
You were asking like 7D2 of the contract where you asked the sellers to install new blinds and coverings?
Window coverings. We didn't say blinds or drapes. We just wanted something to cover the windows because they were all.
You don't leave something open-ended or vague.
I knew you were going to get me on that, but
Yeah,
but I still.
Yeah,
she put in writing
you'd
that.
have to go to a court to determine what it is that the intention of the buyer, what did the seller agree. Clarity is your best friend. Keep it simple. Agents ask me all the time how to say it. Just say it in plain words that's coming from your clients. That's really where it should be the source of. And something like that. And the clearer the better, because everybody will really kind of understand what they're agreeing to. And that's really important on a contract. We don't like the gotchas because they're going to blame the agents on something like that. Either the listing agent should never have allowed her seller to, accept those terms if they didn't understand, all these kinds of things on these type of matters. Be clear. That's the most important part. Okay. The next one is we're going to talk. Pardon me? They could have used CVS receipts. Be real careful about that. Well, I don't know, but yeah, it could be really bad. They're trying to do a better job. I noticed the receipts I got today were not, it wasn't the same distance from Bernie to Houston, but normally I have very long receipts from them on something like that. The next paragraph that is really important for you as a listing agent, because it puts on you the requirement to make sure you have vetted this with your sellers, is paragraph 21I. For years in additional notices, there was never any little box that we ever had to mark. And it's kind of interesting, if agents are not real familiar with when this change came in, it could cause some problems for them. And what happens is the sellers have to tell you, and you're really lucky because embedded in this additional notice, they actually define what a foreign person is. So all you have to do is read it. You don't have to come up with it or explain it. It's there. If your seller says, yes, I am a foreign person, you're not going to put that listing in MLS because you can't do the net sheet. They have to give you a letter from a certified public accountant, a CPA, and they have a seal on it, and it'll be on them if they have not provided the right information, not on you, or a tax attorney. And they have to attest to the liability, tax liability, that this seller will be subject to. And you have to have that from those other third parties, because then you're going to add those on the seller's estimated net sheet. No seller can go forward and list their property unless they know what will be their tax liability on this issue. And here's the thing, once you know it and you've gotten all those documents, there are, based upon the tax attorney or the CPA's advice, there are some affidavits that your seller may be required to sign that says, in the event any information I've given you is wrong, the IRS can come after me, and the buyer will need that. It places a huge onus on the buyer of the contract, and we'll talk next month. We're going to flip that side. As a buyer's agent, what you better make sure the buyer does, because many times we have situations, number one, we have it where the sellers say they're a foreign person and the listing agent has put it in MLS and agent remarks, which they have to. It's not on the seller's disclosure, but a buyer has to know, is this seller subject to this before they present an offer, okay? That's why in agent remarks you're going to put something like that in there. The other thing is that this is a situation where if you've got a title company that says, we don't do that, we're going to make the buyer sign this document that says it's all on them, we're not going to help them or anything, you're going to change title companies. Yeah, not only the TREC attorneys, but the Texas Association of Realtors attorneys, on a big panel that we had on risk reduction about this, they said, if the title company will not assist the buyer with placing it on the closing disclosure, taking it from the seller's proceeds, and then assisting them with the IRS documents, you probably need to go to a different title company. And that came straight from them at our meetings. And so it is a very sad situation for a listing agent if they haven't done this, because it could have an impact where the seller can't sell the property. They may have a tax liability that might exceed their equity or their, their net. So you have to have all this information before you can ever put it in MLS, because the sellers really need to know, this is what, based on the list price, this is what your estimated cost could be. Yes?
Okay, on the foreign tax, if I'm understanding this correctly, it is people that are foreign buyers. It's not a person who holds a green card.
The foreign person is
The seller.
defined as the seller. The definition is in the listing agreement, so don't interpret it, just tell them to read it, and then they are the ones that are going to have to tell you if they're subject to it or not.
Okay, and then on a net sheet, I've stopped doing them myself. I take everything to a title company, and I am having the title company provide the net sheet based upon the information of the sales price, the information of the loan documents.
We're talking about the list price here. We're
List
just
price.
listing.
List. So before I ever list it, I have from a title company already their costs and the title policy, what it would cost for that, as well as we assume a home warranty, we assume HOA information.
Well,
That's
you
all.
as a listing agent should be doing this. Nobody else gets to do it. If
So
you
it shouldn't come from the title company.
You can have the title company maybe provide their documentation that you need for the seller's nest sheet, but bottom line is you're responsible for it. Yeah, make no mistake. And I'll be honest, you don't understand how to do one when you first start in real estate, but boy, you are going to learn how to be perfect at this, because you will be subject to the seller saying, well, I didn't know that, and now, now they're going to make you be the one to pay for any deficit because you didn't really review it with them. Sellers are really tricky like that. So you got to make sure you cover all your bases, and I'll talk about what you might have to modify your seller's estimated net sheet, because the fill in the blanks might not be there pre-formatted on something like that. The next thing is if you represent a seller who has a tenant in the property where the lease will be conveyed to the new buyer, at the time of listing, you will need to get a copy of the current lease and any amendments. You will need a copy of their accounting for the deposits that the landlord/seller took from the tenant at the time the lease commenced. And then you'll need the move-in condition form that the seller/landlord received per the lease terms. Now, you're going to get all of this at the time of listing because in the contract in paragraph 9 and 10, and 10 says that the sellers have to deliver it within 7 days. So you don't want to get somebody who might have to go find all those documents and delay that, because it could cause a problems for a seller who does not comply within 7 days. So again, that's one of the things you better collect on that. And the reason for that is all the deposits will have to be on the seller's estimated net sheet. While the seller/landlord will most likely give those proceeds in a separate cashier's check, because landlords in the state of Texas have to account for everything. And they have to show accounting to the new landlord that I've given you all these deposits. Because the new landlord will be responsible for holding those and then accounting for them with the tenant when the tenant surrenders the property under the lease. So again, you have to have that all together. The one thing we get a lot from the sellers who are landlords is says, oh, I'm going to keep this non-refundable cleaning deposit. Oh, no, you're not. All the monies per the lease will go to the new landlord, the new buyer. So they don't get to keep anything. But what did happen to an agent is the seller, when they got the closing disclosure, the agent said, well, you need to, where's your cashier's check for the buyer? And they said, oh no, I spent that long time ago, I don't have it. So the seller couldn't close because they didn't have the monies from all these deposits. Well, who do you think they wanted to solve that? The agents, exactly. So, you know, you have to be very careful making sure you've acquired all these that might affect a contract that would come on the property. So make sure at that point in time that you've done that. And again, last but not least, listing agents, please sign immediately after the seller, based upon as long as the seller has encountered you and you don't need to figure something out. But please be timely on that. And then, of course, you always give any copy of anything somebody has signed to them right away, the moment they have a fully executed listing agreement. So these are just, this is really the areas where it's so critical that you cover them and you do them well and they're not blank, because it will impact the rest of the transaction going forward in the event that you get an offer on the property. And now we're going to talk about the seller's estimated net sheet. Which ones do y'all like to use? Do you use the Texas Realtors, or do you use Fidelity or Alamo or Stewart? Everybody has their favorite one, and that's fine. I don't care who you use, but you're going to learn to modify them, because they're not going to have what I'm going to talk to you about. And this is real critical for you, because you want to make sure that you covered it with the sellers. That's your best. And this is your document, so they can initial every little thing, or per seller if they gave you a payoff, and all these types of things. So again, I don't care which product you use, you're just going to have to modify it and add some things and make sure that the sellers, if you relied upon the sellers to provide you some documents, that you're going to say per seller and have them initial that, because you want the source. So how did I rely upon this number that I put on this estimated net sheet? And so you want the sellers to be responsible for this. The other thing is if there is an existing lease, you're going to have a notation that will say deposits from lease. And then it will be the total dollar amount that landlord/seller will have to give those proceeds separately. Most of the time they're not on a closing disclosure, because most landlords aren't going to count that way. It'll be prior. Buyer's agent, make sure that your buyer has those in their hand before they close, okay? That's real critical. We have a lot of buyer's agents who a month later are still trying to collect all those funds. That's not what you do. It's prior to your buyer closing that you will get those funds. So again, you might have to have a notation. If there was a loan modification, and everybody says, what is a loan modification? Okay, here's the sad part. Sometimes you have to have these real delicate discussions with the seller so that when you're on this net sheet, you're going to have the accurate information for them. You're going to say to them, at any point in time were you ever in arrears on your mortgage and you had to contact the lien holder to get a loan modification? It has to be that purposeful and that clear. And the reason for that is, believe it or not, a lot of sellers, they got into trouble, they got a loan modification, and then they said, oh, for the last 2 years we've been perfect, we've been paying the same mortgage note, which they do. Because what they didn't realize is they signed a separate lien. And that's a separate note that is attached to the property. And so while they think they just have one lien, they don't, they have two. And we have had them from anywhere from $40,000 to one guy last week told me $91,000. Those sellers could never have sold the property. Most of those loan modifications, if you look at them, that happen under $350,000, that loan modification, that separate lien, will actually place them out of the market. They'll never be able to stay in the property long enough to have enough equity on it. It's really sad. You know, they're looking at it from a quick fix standpoint. They don't realize that they have another lien out there. So, but that's your job. So be very specific. When you put loan modifications on your net sheet, and they say, no, we didn't, you're going to have them what? Initial it per seller, and you have them initial it, because I don't want you to be responsible for not having covered that delicate element with them. And it usually has resulted that they cannot sell the property. It would have to go under a different type of transaction, which would be like a short sale or forgiveness by the lien holders on that. Have any of you ever been involved with those? They're devastating. The buyers have already spent a ton of money. They're ready to close, and then the sellers find out they can't close. Those buyers come after the listing agent for all the damages, all their inspection, whatever dollar amount they want, and that's what the listing agent will have to pay on something. If the seller lied to the listing agent, well, that's a different matter, isn't it? We can go after the seller, but if the seller lied, they don't have any money, good luck on that one. Do you know what I'm saying? That's just a situation that presents itself. We want to really cover that. And then with the FERPTA, again, you'll have a separate notation. You're going to have a notation for lease deposits, for loan modifications, for FERPTA. And if they say, no, I'm not a foreign person, it's per them, and that's in the listing agreement. They'll put none in there, and you'll have zeros, and they'll initial that. Those are the critical areas that really involved TREC complaints for the listing agent, as well as sellers saying, well, I told you that. And many times that's how sellers do it, because if you're not real good on the seller's estimated net sheet, they'll say, no, I told you about that. Why didn't you do that? The other thing is, why do you think they need an estimated net sheet when they list the property? Can I list that property for that list price? That's exactly right. Now, the seller comes to you and they need to amend the listing because they had a little too high expectation what their property might be able to sell for, and so they want to amend the list price. You better do another seller's estimated net sheet to save you, period. That's why I'm saying you'll become very, very proficient at this, because you have to do them constantly, especially on the listing side. Every amendment that amends the list price, you have to have another one signed and executed by them with all of that. The other thing is that when you get the offers, every last one of them will have to have the estimated net sheet based upon that offer that's presented. Most sellers look at a bottom line number, right? But you'll go through various things with them on those types of components. But on the listing side, make sure you put the commission on there. We have one team that just loves to do the estimated net sheets, but they leave the commission blank. Well, that's not what I would call very forthright and fiduciary, like for a listing agent to do that. That seller really needs to know, and that a lot of times, unfortunately, it's a pretty big number, right? And there's a big number because it should be a big number. It's a big task that we have to do. But again, make sure that you don't leave that blank. That can be problemsome for you as well on something like that. Aren't we having fun? Okie dokie. Now the seller's disclosure. Well, do you see the date up there of 9/1/2019? If you represent a seller and you don't have the latest seller's disclosure, you're going to get one today. As a listing agent, if you didn't do it, it's going to fall directly on you. Because not only did we talk about it for months before, when the governor signed it from June, we talked about it, that it was going to be mandated as of September 1st. If you didn't have a contract from August 31st or before, as of September 1st, that was the only seller's disclosure the sellers could provide. Because here's the problem. If you didn't do that for your sellers, you didn't assist them with complying with the law. The law changed, and they're only going to blame you because that's exactly where it should fall. You're the professional. If you don't assist them with meeting the law, what good are you? And everybody knew about this. This was not something, it was directly related to the Hurricane Harvey events, why they had to add those new 3 sections to make it clear about properties that might have been subject to that. So the problem for you as a listing agent is if you give an incomplete seller's disclosure to a prospective buyer, right? Your sellers have a tendency not to be good on detail, and you never looked at it, and you never submitted it to compliance review, and you gave it to a buyer who's presented an offer, and the buyers have signed it, right? Then when compliance says, well, you're missing section 2, section 1, all these different things, you are going to have a difficult situation to go back to your seller and say, we need to update the seller's disclosure because now the buyer has a free walk. And so you'd have to explain that to your sellers. And I don't know about you, but if that buyer has a free walk, I think the sellers are going to come after you. Not them who didn't complete it. They're going to come after you. And that is your responsibility. You cannot forward an incomplete document. We have no idea if it's accurate, but it has to be complete. Every box marked, every why answered, explained, no ifs, ands, or buts. And the great part about it is Seller Shield now has a free wizard for you. And when the sellers go into it and complete the Texas Realtors one, if they have a lot of explanation for an event that needed to have a why answer, they just elongate the form and it's clear and everything and it just extends it. But Seller Shield has a little shield in the lower right-hand corner of a seller's disclosure that a seller has completed using the free wizard. That's really important because any good plaintiff attorney knows that Seller Shield was created by attorneys and that the listing agent and their broker wasn't involved in the sellers completing it at all. We have one broker associate who has been using this. The minute I told him it was free, he made all his sellers hop on and use it. His sellers contacted him, 2 of them have contacted him last year and said, did you get this demand letter? And when the agent contacted me and I looked at it, I said, well, I know why, because the plaintiff's attorney's not stupid. They're not going to bring you into something if the sellers didn't complete it properly. They know that the sellers did that and you had an arm's length. Both of those, we were not in the lawsuit. That's revolutionary because normally plaintiff attorneys, especially with sellers who have completed it, either through dot loop or by hand, they pull the listing agent in because they want to say that the listing agent assisted them in not providing all the information, not complete information, those types of things. The other good thing about Seller Shield is they won't let the seller sign and date it till it is completed. There are also several areas on the disclosure that says if they say yes, they're going to attach an on-site sewer and septic. So that document comes in through Seller Shield. Then if the sellers say, yes, my property was built before 1978, they have the addendum for lead-based paint. While it's on the contract, that's one document you want to make sure is, God bless you, is perfectly done because it is part of the contract. It's in paragraph 22. The other one is in the event that they have said that they have a flood insurance or they live in these areas. Texas Realtors 1414, information about special flood hazard areas, it will be auto-generated. The only thing that you'll have to look for will be if in section 10 they mark that there were previous inspection reports and they identified it, you will have to get those reports from your sellers because those are going to come only from the sellers. So again, Seller Shield kind of takes you out of the loop on this, takes a lot of headache away from you. It legally advises the seller while they're completing it. They explain what the provision means. And so it's an awesome tool, but I love it because the agents who are using it now are not being named in any dispute regarding the seller's disclosure. And that's real important. Yes? Well, it's at sellershield.com. Your broker provided the list of all the emails, but you'll go in and make sure that you're all signed up on that, and then you invite your sellers into it, and then the sellers will complete it. Yes?
I sent that Seller's Shield to a client, and he said that because his property is an investment property, that he couldn't use it.
Yes. Investors are not owner-occupied sellers. They're a higher risk, period. So they're not going to get coverage if they're an investor.
And are they even able to use the seller's disclosure form on that site? Because I had hoped he would at least use it, just to have the form.
Probably, they can't have the legal contract, but I'm not, there's no reason why they can't fill it out.
Because he ended up doing it on .loop, so.
Well, as I said, I don't know that they're stopping you. I don't know if they ask you a question about who you are or where did you acquire this property. I don't know that. I don't think they do. But he can't have the legal contract. That's absolutely correct.
But if we gave it to him through .loop and he filled it out in .loop, then that's proof that I had no hand in it, right?
Absolutely not.
It's not?
No, ma'am.
Then how can I cover myself?
I don't know, other than saying, in an email, I thank you for completing the seller's disclosure.
Oh, I've got plenty of emails. Yeah.
You're going to have to make sure that you weren't in the neighborhood, because one of the co-founders said that he doesn't even want the listing agent in the neighborhood. And I had a poor little listing agent call me back. She said, but I live in the neighborhood. I said, what he means is he doesn't want you around while the seller is completing it. Yeah, that's what you have to have verification of, because they're always going to roll on you and say, oh, no, I asked the listing agent and they told me to mark Y, or they told me to mark no or unknown. Do you know what I'm saying? And therein lies your biggest problem on something like that.
There's one question on the seller's disclosure that almost all of them I read is answered incorrectly, and that's about the water conservation.
Oh, it is.
And so
absolutely.
my question is, when I talked with you a few months ago about it, I went to a website and got a map, and I provide that map to every person I'm listing. And I tell them that this map, if they read it, will tell them whether or not we're in a water conservation. And if it does, that they can use this map as an attachment. Am I doing that correctly?
Yeah.
Okay.
This a broker associate who's been out of, he has it attached, and she's talking about the TCEQ map. You're either in a subsidence district or a water conservation district, and he attaches it to the listing agreement. So it's a proof of a record that I gave it to the sellers, and I told them if the sellers answer it wrong after that, it's on them.
So the next question would be, if you are representing a buyer and you get it and it's answered incorrectly, what do you do?
You're going to review that with your buyer, big time. The buyer's going to make the decision about what they want to do.
Should, at that point, if the buyer says, I just want it amended, what do you do with that? Tell the sellers?
Yeah.
Okay.
That's how it works. Listing agreement needs to be updated, that the update to the seller's disclosure. Pardon me? The TCEQ, that's the Texas, it's in the quality, anything to do with water in Texas is on that site, TCEQ. It's not the easiest website to navigate, but just hang in there and learn how to use it. It's really great. But there's a map. It's pretty easy to get the link that shows you the map for all the districts in the state of Texas. The map is updated quite often because districts are being added, modified, or changed. So it's not a document that you probably won't go visit quite a bit and try and do that. The other thing you're going to tell your sellers, they're going to say, well, why do we complete this Texas Realtors 1406? It's bigger than the Trek one. Yes, and you're going to let them know that because most of the lawsuits that involve sellers selling their property revolve around them not giving enough information to a prospective buyer about what they know about their property. And we're helping you by allowing you to divulge more about your property to a prospective buyer. That's going to protect their interest, right? Besides them having to be truthful on it, it's better for them to have more information. We have never had a seller sued because they told too much or disclosed too much. That's a fact, okay? And so just make sure that they understand that's the reason we do that, is because we're helping them, and those type of things. The other thing is, if once they are under contract, they have to know that the property is in a different state. While they own it, it's in that state of a contract, right? Anything that happens on the property, does the buyer have to know about it? Yes. And we have a lot of those issues where something, a sudden discharge on the HVAC or the overflow plan or something in the upstairs bathroom leak, all these different things, that buyer has to know immediately on something like that. They're going to become engaged with it. Sometimes some sellers feel like they might have too much say. Well, that's their property that they're acquiring, and they're going to want to make sure that the repair was done properly and everything has been taken care of. So just remember that to go over with the sellers, because the sellers live in the property, you don't, as the listing agent, and maybe they might not tell you something and they've said, oh, I just went and called the plumber and had it fixed. That's not those kinds of things that they are not supposed to disclose to the buyer under the contract when they're under contract. Yes?
If the property effective year build was 1978, it's considered not before.
She's asking a question on page 2 of the seller's disclosure. Was this property built prior to 1978? Would December 31st, 1977 be prior to 1978?
Yes.
Thank you. That's it.
So, it's yes.
If it was built prior to 1978, the answer would be yes.
It was not built before.
Well, if it wasn't built before 1978, they're not subject to the lead-based paint addendum. Only properties built prior to 1978 are subject to the lead-based paint addendum. On the seller's disclosure?
No, on the tax record.
Oh, well, I have no idea what the tax record said. But usually a person knows the age of their property. But you're not, you give them all the information that you print out, and then they have to verify it, right? Sellers a lot of times don't look at all this information. They could care less. It is a lifeline to us, and especially if you have 3 different appraisal districts or resources that show 3 different things, right? You're going to have the sellers confirm those things for you. You're not going to make the decision on your own on something like that. So again, the seller's disclosure is very, very, very important to make sure that the sellers really are completing all of this in their best knowledge. You don't answer any of the questions. The moment you do, you are now sucked into it being your disclosure. Because they're all going to say under oath, oh no, the agent told me I didn't have to tell you that it flooded because see, we fixed it. Not the case, so just be careful about that.
Wait. Sorry. So can you go back one slide or no? So let the sellers know that the TXR 1406, so do we give them both? The seller's shield disclosure and have them fill out and this?
Well, once they use the wizards from Seller Shield, you don't have to give them anything because Seller Shield provides it all. They're filling it out on Seller Shield website. So and once it's completed, every box marked, every why answer explained, then Seller Shield will allow them to sign and date it, and then you'll get a copy of a fully executed one. The only thing you kind of have to look at is that section 10 that'll talk about previous inspections, because you'll need to get those copies of it, because you have to bundle it all together and prove that you delivered it for the seller.
And so the inspections, is that 4 years from the date?
Okay, my book is, if you have any inspection report on your property, while the form says within the last 4 years, I'm not going to split hairs on that. I want them to disclose anything they may have received or know about the property. That's the way we should be, and that's really what that wizard does with them. It kind of goes through that part on the disclosure. Multiple offers process. Have any of you ever received multiple offers as a listing agent? Yes. Well, let me just tell you how we have gotten into trouble on that as a listing agent. I have a difficulty with agents not understanding that their sellers have countered a party. And that means that the listing agent, the seller said, you know, I looked at this offer, but if they would do this, or raise the price, or change the date, I'll sign it, right? If you as the listing agent say that to the other agent, is that a counter? Absolutely. And that is where you get into serious trouble. You don't have binding authority for them, so you can't say they will sign it, because you don't get to hold a gun to anybody's head and force them to sign anything. The problem for you is your language will sink you on this process if you don't do it perfectly, okay? Because the other party is going to rely probably on what you convey. There is a document, TXR 1926. It's a seller's invitation to buyer to submit new offer. This is where the seller will send back, and it clearly states, I didn't accept your offer. Yay! Now there's clarity. Nobody accepted your offer, but here's some tips, and if you submit a new offer, I might consider it more favorably. And at the very bottom, the last paragraph says, this is not a counter offer. I am free. If somebody comes in the next minute with another offer, I'm free to accept it. So that form is the best form that you could ever use as a listing agent. Because here's the scenario that I had last night. On Friday, the agent put it in MLS. On Saturday, they got an offer. They countered. And then yesterday, they got a cash offer more than the offer that had been countered. And the listing agent said to the second buyer, you know, we're in multiple offer. And the first buyer, when they found out that the seller had gotten another offer, they went through the roof, because the listing agent had said the seller will accept it. Everybody in this room knows we have no binding authority. We can never, ever state that a buyer or seller will do something. We can't. They can change their mind on something like this. But the agent did it. She didn't handle it well. And there is this form called the Notice of Withdrawal of Offer by the seller. It's for buyers and sellers. They get to withdraw their offer or their counter offer. It's in writing. It's TXR 1945. The seller could never have even mentioned to the first buyer about the second offer until they withdrew their counter offer to that first buyer. There's going to be fireworks, because the first buyer is going to rely upon everything. They're going to hang everything on the listing agent. You text us and said the seller will sign. Yeah, well, it is a problem for you as a listing agent. No listing agent in their right mind would ever say somebody will do something. The only thing we can confirm is when they have done something. Do you know what I'm saying? You can't say that. Even if the seller said to you, Marilyn, I'll sign it. I'm not stupid. He could change his mind. We had one that was so upset when the Astros won the World Series that year. He went to a game, and the Astros didn't win. And before the game, he told the listing agent, I'll agree to that amendment, right? So the listing agent told the buyer agent. So the buyer didn't terminate at 5 o'clock, before 5, right? Well, the seller got home and was really mad about the Astros not winning that night. And the seller says, I'm not signing it. And boy, those buyers fired off a truck complaint to that listing agent and everything. That's what I'm saying. You have to be very careful about your language. This seller's invitation is the best way for the seller to make a hard decision. But make no mistake, the seller's going to make the decision. And you're going to tell the seller, even if they just put the property on the market and they got that offer and they're excited about it, one day in, how many of you would think that the seller might not get more offers? You know what I'm saying? Right. To keep the seller safe, you're going to visit with them about this document, that this is probably the best way. Because then the listing agent wouldn't be accused of doing all these things. You know what I'm saying? The sellers are out of it. They're saying, hey, it's all on you. Whatever you did, listing agent, you better fix. That law firm better be out on the Keller Williams sign, because you're going to be having to fix this, not me. So So be very careful about this. Counters are not just in writing. It's when you verbally say something from one party and you're passing it to the other party. That seller's invitation is the way to stay out of trouble. But the seller gets to make the decision. But the seller has to know you don't get to respond to any other offer until either this one is successfully withdrawn or you have an executed contract. You're in it until one of those two things happens. And as I said, that notice of withdrawal of offers should have been given to the first buyer. The listing agent talked too much, as all agents do. You know, they wanted to say, you know, the seller was going to sign it, but then this other offer came in. They're talking way too much, way too much. So again, it puts a very, very difficult situation for your seller because they're wanting to only sell the property, right? They want to accept that second offer that came in that was for cash. Had the agent used the seller's invitation on Saturday, that seller would have been free to execute that offer that came in on Sunday, okay, instead of responding to the other process. Yes?
What about for sellers who do not respond to offers? Is it considered still an open offer?
It is. The buyer, if the buyer found out that the seller is not going to respond, and really as a listing agent, we always want the sellers to respond, don't we? Preferably decent and without bad language, especially on low offers. But as a buyer's agent, and we'll talk about this next month, you have to present the notice of withdrawal of offer signed by your buyer to the seller. Otherwise, the seller has it. You know, and they created this form because the agents were getting too many truck complaints. We were getting into too many bad situations, and so they realized that before we had to date and time stamp it through emails or some kind of confirmation that one party said, I withdraw it, right? And then the other party came back, oh, no, it's too late, I already signed it. And they signed it wet signatures, so we didn't know the date and time. You know what I'm saying? We had so many issues on this. That form is got several processes. If a seller has said to a buyer, I withdraw my offer, they're going to have to prove when they did that and fill that in on that form. And if they haven't previously communicated that, they'll select the second paragraph. But make no mistake, it goes both ways. This is a form for buyers to use as well as sellers. Okay? So you have to be very, very careful. Our problem with our listing agreement is we tell the sellers in paragraph 11 that we're going to tell all parties that they're in a multiple offer situation. And the reason we do that is because we abide by the code of ethics. Do you think a buyer would want to know if they're in a multiple offer situation? Yeah, that's it. Sellers don't take a code of ethics. But we always have to abide by it, no matter what. We may represent the seller, but we cannot treat the other party unfairly. And so I don't know about you, but there's every buyer on earth, when they submit their offer, they not only want to know if the seller's received it, but they want a response, don't they, on something like that. So the sellers have to know we don't shop terms. We abide by the code of ethics. The only thing we're going to tell them is that they're in a multiple offer situation. All parties will be told that. No more. No privilege to one agent because you like them better and you know that their buyer's always closed. We've had those problems. We have a lot of them where they might have received a multiple offer from another agent in the same office where the broker's intermediary. They've got the two agents appointed on the transaction. So again, you have to be very, very careful as a listing agent not to play favorites, not to give information to one party that might advantage them over one of the other parties on the process. And I'll tell you, I cannot even count how many issues we have had where listing agents have used language that would mean that their seller would sign or would agree. Or one texted me or sent me an email when he was on a cruise a couple of weeks ago, and he said, I don't think we countered. And the listing agent at the end, he said, yeah, you get your buyer to agree to all those terms and make the changes, and I'll get this thing wrapped up with the seller ASAP. Yeah, it was very short, my response back to them. I said, yes, you countered. So you need to learn what countering is, because that's what's going to get you into trouble on some of these things. As I said, the seller's invitation. I'm going to tell you, there's an agent at the Metropolitan. His name is Weldon Rigby. Do any of you know him? Yeah. Weldon sits on the front row of my training every time. He's been a broker associate with us since he folded in his brokerage, but he's been a broker for 50 years. And last week he raised his hand. He said, Marilyn, I use this form in my presentation at the listing. So everybody in the room's kind of thinking, what? He said, yeah, I told the sellers, I said, I'm not so free to give away all of your equity. And I want to tell you about this form that I really encourage you to use in the event we get into a situation where you get presented an offer and you maybe don't like the terms but would like to let them know that. Well, anytime you have an agent who says, I'm not free to give away your equity, I'm going to fight for it more, and I'm going to show you a form that helps us do this, I don't know about you, but I bet you he wins those listings. And he does. And so he was giving a different angle on it that I don't think a lot of agents had ever really thought of, because that's really why your seller is hiring you. Not free to say, come on and accept this first offer that you get on a one day on market. It's really to be working in the seller's best interest. And while the seller may make that decision, you're going to say, we have options we can use. I've done this net sheet and you're not comfortable, I can tell, with this. What would you like to tell somebody but not counter them or be tied to them? That's why this form is used. It's a great form. It keeps agents out of trouble. That's why I like it the best on something like that. And that's when you learn to list to last, when you absolutely understand what it is that you need to do in the seller's best interest. Because the poor sellers, once they accept a contract, either the only way they can terminate is if the buyer doesn't deposit the earnest money per the contract now, or the buyers are in default. They don't get to make a buyer go away because they don't like them or something's not going well. They're in it. They need agents who really explain the process, are willing to present good options to them, and then let the sellers make that decision on their own. But you're always going to provide the good options to them. That's your job, to be able to do that as a fiduciary. Has any of you ever used that seller's invitation to buyer to submit new offer?
I just had a listing presentation. I presented the form for them.
It's the sooner we can present forms to a party before they're actually used in an offer or something is better, because they're not focused on the right things typically when they're in the process of receiving an offer and going through those terms. You always want to try and present it to them when they're calm. And that's usually before they ever get the pictures taken and all the showings, you know what I'm saying, and the inspections and all those type of things. So it's really good to be able to prepare them for this process. And I heard an agent the other day on the radio, they have a program, and they said, you know, I have sellers who haven't sold a home in a while, right? And the seller was shocked when they saw the seller's estimated net sheet. They said, well, when I bought this house, it only cost $195. Now it's $695. You know what I'm saying? So that's what happens. We are constantly in an information mode to them, an educating mode. We have to be the ones that present the proper information to them. They get to make the hard decisions, but you better give them all the good options that they might have on something like that. All righty, are we happy now? Earnest money disputes. How many of you have ever been in earnest money disputes? Personally, I would love for earnest money not to be on any contract form, but you know, years ago they used to call our contract form the earnest money contract. But they found out that there doesn't need to be earnest money for a contract to be binding between the parties. It was negotiable, that type of thing. But again, let the sellers know that while you can give them the right options and you can provide them the right forms and facilitate for them, you cannot go out and get their earnest money for them, even if they're due it, you know, if their demand is legitimate. They might have to, at some point, be able to enter into a legal contract with an attorney to assist them in this dispute. Because what happens to the seller is if a buyer terminates or defaults and the earnest money becomes an issue, the parties may have a terminated contract because they may have completed a form, like it could be the notice or it could be the release, because at the top of the release it says the liability is released from the contract. But until they have it mutually signed, the seller is holding their breath. Because today's buyers, we have several buyers last year that were not due the earnest money, but they got an attorney and they put a les pendens on the property. The poor seller was getting ready to go to closing on the second contract, and the title company said, oh no, this popped up today, we can't close. Do you know what I'm saying? So your sellers really have to know that this might be a legal battle that they will become involved in. A lot of sellers have made really sad situations, made very difficult decisions. They said, I'm getting rid of them, release it, I'm going on. Some sellers say, no, I'm not going to release it. Well, then you know you've done everything you can. They will probably need the assistance of an attorney to take them forward on something like that. But title will not close a transaction if they find out that there's earnest money dispute on a previous contract for the property. They just don't do that. And because agents talk too much, everybody knows where you close your transactions. So they send out all the notices to the escrow officers at those title companies, letting them know. It was pretty easy most of the time for us as buyer's agents to track down where that transaction was escrowed, the second contract. So again, be very, very careful about making sure that the sellers understand you can facilitate only so much. You can provide them their options, tell them to seek the advice of an attorney and give them the right forms, but you are not ultimately responsible for securing their release. Okay, that's mutually done between the parties on something like that. The thing that I had yesterday, which was kind of interesting, an agent called and they said that the closing was on Friday, but the buyer didn't close. I said, well, what did the seller do? Well, what do you mean? I said, well, as a listing agent, if the buyer didn't close on the closing date, the seller has options, don't they? They can hold the buyer in default and terminate the contract and demand whatever they want. And there's a notice of seller's termination of contract. And one agent said, oh, that's a new form. I said, no, it's over 2 years old. It is not a new form, and I have talked about it consistently. Because what happens is if the listing agent doesn't assist the seller in being the first to throw down the gauntlet, there's a chance that the buyer agent is going to submit a notice that's not accurate. We have too many buyers who say, oh, I didn't get my third-party financing approval, and so I'm demand my earnest money. And those number of days are long gone. But now the seller is in a fighting mode with the buyer because the buyer terminated improperly. They didn't have a provision to terminate. So listing agents, make sure that you give your sellers the options at the right time. If they didn't close by 5 o'clock on Friday and the parties haven't reached an agreement to extend the closing date, the seller should be the first one in to let everybody know, I'm holding you in default because you did not close per paragraph 9 of the contract. This is real simple, that process. But we've had a lot of sellers who didn't do that because their listing agents said, well, the buyer's already sent a termination notice. I said, well, it's not accurate. And I said, so why didn't the seller send theirs when the buyer didn't have a provision? I don't know. We thought because they sent it, it was, I'm thinking, you had better understand the process here, the use of the form. Why do you use it? You're representing the seller's best interest. And so your seller has to know that we have these forms. And truthfully, when a seller sends that form and they're the first one in and it's real obvious the buyer didn't close, it's not going to be highly disputed unless they're idiots and want to spend a lot of money and lose a lot of money. Because if a seller has to take them to a small claims court or something else, small claims court, believe the justice system kind of looks at like, what did the parties agree to in writing? And then they usually ask, well, did you close? No, we weren't, the lender wasn't ready. Well, you know what I'm saying? Time and time again, they look at it based on what the parties agreed to in writing. It's amazing how many times the sellers will prevail on something like that. Again, some sellers say, oh, I'll give them a few more days. Well, great. We'll do an amendment to the contract on Friday before 5. Don't leave it to be after and it's already passed. That's not really good. Now, if your sellers want to do that, you better get it in writing because that's not how we work. You know what I'm saying? We do things in the best interest of our clients, and so we would want to make sure that they made the decision on something like that. Everybody has to get to a microphone to ask a question.
Okay, so my question is the seller's termination of contract. What is the form number for that?
Notice sellers of termination of contract, I think it's 1950, but don't hold me to it. I got lots of numbers in my
It's
head.
called seller's termination of contract.
Notice of seller's termination of contract. TXR, it's a Texas Realtors form, 1950.
TAR, okay. Thank you.
Uh-huh.
If seller terminate the contract and the earnest money still is in dispute, can the property still be sold or stays in dispute until that clears?
No, the seller, once the seller has declared that the buyer is in default and I terminate the contract, they can put it back on the market. The problem for the seller is you better have this all tied up and mutually released before you close on the second contract. Because we have a lot of antics going on by buyers, agents, and buyers putting a provision that won't allow the seller to close the second one, and it takes a lot of time for the release of those types of documents. So we never know how a buyer is going to react to something like that.
Title company doesn't release the earnest money unless buyer and everyone signs on that. And until
Correct.
they have that, they don't open another escrow on a new contract.
Well, most title companies will not accept a new contract on a previous dispute of release of earnest money on the same property. You usually have to go to a different title company. Most title companies won't have the two contracts, the one that's disputed of release of earnest money and then the new contract.
So I understand correctly, if seller terminate because the buyer is in default and didn't show up for closing, we can still open a new contract and another title company.
Yeah, the seller gets to make a decision based upon us giving them their options. We're not going to say that it's okay and you can hide this. Good luck. As I said, it has been uncovered because agents know where other agents close. From your previous transactions, the data in the MLS and those type of things. The seller needs to know that our recommendation only is that you get that release mutually signed. I don't care what you have to do, but you're going to get that done prior to you closing on that second contract. That's the best way. We've had one Trek complaint. It was from an agent who'd been in the business 30-something years. And Trek ruled that she assisted the sellers in going to a different title company to close it. And the buyers came after the listing agent because she really had advised them legally. So you have to be really careful about what you have to point to the provisions that they have in these types of things. But you always have to have in writing, but you need to find out legally what your next step will be, okay? Once a seller knows that the other party is terminated or the seller is terminated, they can put it back on the market. It's just those are little things that they're going to have to resolve before you ever go forward and close on a second contract. Okay. Hijacked listings, yes, they are still happening. I am going to tell you that instead of you having to sit in front of the computer every day and pull up every one of your listings, you're going to get each seller to say on a daily basis you need to go out there and just Google your address and see what comes up. We're hitting into the market in the spring mode where we have lots of hijacked listings for sale, but they're for lease. And those scammers collect all these deposits, and then those poor tenants go to the property thinking that that's the property that they went under a lease on, and it's a property for sale. So again, be very careful about that. Make sure that you tell the sellers to do that type of thing, that does happen. Then the sellers will have to contact whatever site it was to tell them to remove that, because that's, it's fraudulent. They don't have a listing agreement on things like that. So we're getting into it. It's cyclical, but we're getting close to the time where that happens a lot, where things turn up. The worst part was, it was the worst scenario. This poor little couple, these tenants had given all this money, right? And the agent, quote agent, said, don't worry, the back door is always open. Just go ahead and go on in. And the little tenants pulled up with their little mini U-Haul. And when they tried to go in the back door, the seller had a shotgun. And we're lucky they didn't kill him. Isn't that sad? You'd have to be very careful about these types of things. And that takes me to this. Tell your sellers they are never going to open the door to anyone and allow them onto the property or inside the property without a previous appointment. And here's what happens. Case in point, they're outside doing yard work. A crazy agent drives by and jumps out and says, oh, when did you put your house on the market? I was in MLS and I didn't see it this morning. They said, oh yeah, the agent just came, put the sign up, it went in MLS today. Oh, I have these buyers and they're in my car and they want to see your property. You're going to tell your sellers, there are agents that are so crazy that do that all the time. Well, one seller said, well, they gave me a card. Well, anybody can get a card, right? You have to be very clear. Never, ever can they ever allow anybody into that property without an appointment. What they would say is, you need to call my agent, blah, 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 those type of things. Please don't let them in. I'm going to tell you a story that really rings true, and this is why you have to be very specific with your sellers about this. Wendy Harrelson had a listing in Austin, and what had happened is the seller was there when a showing was going to happen. And what the seller went to the door, met the buyer agent and the buyer and said, if you need me, I'm going to be out of your way. I'm going to be on the back deck. Okay. So the seller saw the buyer, right? They let him into the property with their buyer agent. A few days later, the buyer shows up and knocks on the door and says, I've tried to contact my agent because I need to check that back room because I'm using it for a studio or whatever, and I'm just waiting for them to get back with me, so I'll be out here. And she said, well, come on in. And he killed her. These are the types of things that happen, and it's the saddest thing on earth. So you really have to be emphatic about that with the sellers. Don't ever let them kind of let their guard down because of the familiarity that they saw somebody or recognized somebody. Nobody comes in their property without the appointment, okay? The next one that I have concerns with is minor children, unsupervised minor children on the property. We have a lot of problems with this with tenants. The landlord has not vetted this properly for you and not given you proper information as a lease listing agent. As an agent for sale, you're going to find out, we had this situation at Christmas time. The kids were off of school, right? Well, the young lady who opened the door, our buyer agent called me, the young lady who opened the door, she said she appeared to be maybe like a senior in high school, but she didn't know her age, right? Turns out she was 17 years old. She was there taking care of her younger brother and sister who were all off of school. Their parents were at work. And the buyer's agent and the buyers, they all backed up, went backwards, closed the door, said thank you very much, locked it all up, put the key away, and then called the listing agent. Nobody enters a property with minor children that are unsupervised. It is so dangerous for everybody involved, much less those poor kiddos. And again, parents aren't thinking that way. They're thinking, she's a senior in high school. She can certainly take care of the siblings while they're there after school or, on their break. Yeah, but not let anybody in the property. So make sure you cover that with your sellers, that there will never be any minor children on the property unsupervised. If there are going to be, those hours are going to be blocked out and no showings will ever happen during those hours. Okay, you have to be real critical on that. As I said, we have a lot with landlords who don't vet that with the tenants, and then the listing agents thinking what? They can just go and show it or make the appointment and show it, and that is very, very serious for everybody involved on something like that. The other one is that the wiring instructions, the scams that are going on, they're getting more sophisticated. The language is being used that is more convincing from the agents. Case in point, when I was at the Metropolitan, they told me that on Monday, the buyer agent got a call from the buyer. Buyer said, I just got this email that said for me to wire X number of dollars. Their closing was in about 3 days. And the buyer called the buyer's agent and the buyer agent had told the buyer, not just when they signed the form, but 2 weeks prior to closing, almost on a daily basis, she said, you are never to respond to any email you get. Do not call their number. You talk to me. You don't do anything until you talk to me. And apparently it worked, because they just hounded them on a daily basis because they're so worried about it. So the buyer called, and the agent said, oh no, that's a scam. That's a hacker who's gotten in. They were saved. Okay, so in this instance, it's not just a form you get them to sign and you think it's great. Man, the minute you go under contract, you're going to be deliberate about telling them, you don't get to call any number they put on the email. You must call me, not do anything until you talk to me. Okay, because you're going to be able to say what? Hey, that's not legitimate. Do not respond to it. Something's happened, okay? The other thing is, we have a situation where sometimes where title will say, will you get the wiring instructions for your client? Any title company that ever asks you to be part of getting wiring instructions or giving wiring instructions is never ever going to have the privilege of you or any other Keller Williams closing there, and they need to know that. They cannot put you in the middle of it. Some fee attorney offices are relaxed about that, and they're kind of sucking the agents into being a participant in that. Absolutely not. They will never, ever get any Keller Williams business. This is a very serious matter. The agents that have had to pay money out of their pocket have ranged from $16,000 to $40,000. And if you participated in it and you were hacked and it came through you, they're going to prove that you were responsible. So these are all very serious matters on this. It's still happening. As I said, I represented a party that represented the sellers back in 2015 when this happened. So it happens for sellers and listing agents too, so make sure you cover that. Nobody will ever ask for wiring instructions. They are never to respond to any kind of email. They need to call you first if they've received anything like that. Whew. Any questions?